Ladies and gentlemen, good afternoon. My name is Vladislav Lanovoy. I'm an assistant professor of public international law at Laval University in Quebec City, Canada. And in my capacity as a co-chair of the ASIL interest group on international courts and tribunals, and also on behalf of my co-chair, Dr. Massimo Lando, assistant professor at Hong Kong University, as well as members of our advisory board, I would like to wish you a warm welcome to this event on interstate reparations before international courts and tribunals. It is a particular honor for me to introduce our distinguished speakers, Dr. Christiana Alborn, who is Assistant Professor of Public International Law at Trinity College Dublin, Dr. Alice Olino, who is Assistant Professor of Public International Law at Milano Bicocca University, and Dr. Yusra Swedi, who is Lecturer in International Law at University of Manchester. Each of our speakers have made important contributions for their scholarship and professional activities to our understanding of the law and state responsibility, as well as the practice of international courts and tribunals. Another unifying thread of our speakers is that they have all published or are about to publish their monographs with Cambridge University Press, who is the publishing house of the American Journal of International Law. Now, international lawyers in the audience, whether in academia or in practice, will be all well too familiar with the Permanent Court of International Justice's dictum, even though it goes back to 1927, and the Factory of Khrushchev judgment on jurisdiction, and I quote, "It is a principle of international law that the breach of an engagement involves an obligation to make reparation in an adequate form, complemented yet by another dictum by the same court in its later judgment on the merits in the same case, namely that reparation must, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed." Now, these century-old dicta, however straightforward and thus appealing that may sound to us as lawyers, do hide the complexity that lies in the determination of reparations by international courts and tribunals. For in the same Factory of Khrushchev case, the PCIJ stressed that the secondary obligation to provide reparation was already at the time a principle which seemed to be established by international practice, and in particular the decisions of arbitral tribunals. Now, the court was referring to a wealth of arbitral decisions from the late 19th and early 20th century at a time where the conditions themselves giving rise to reparations were framed quite differently from what we know today. And predominantly, we were talking at the time of cases, a particular category of cases that involved breaches of certain obligations that states owed to foreign nationals, aliens, and their property. When 2 decades later, in 1949, the International Law Commission, the ILC, embarked upon the codification of the law on state responsibility, one thing was for sure is that reparation was definitely the topic that was ripe for codification. It was so then and remains today the chief legal consequence that flows from the commission of an internationally wrongful act. Now, let us fast forward to 2001, when the ILC, under the leadership of late Judge James Crawford, finally adopts the Articles on State Responsibility for Internationally Wrongful Acts, ARSIWA. The Commission was able to benefit from a significant and much more diverse body of case law on different questions of state responsibility, stemming from the International Court of Justice, interstate arbitral tribunals, the International Tribunal for the Law of the Sea, regional human rights courts, Iran-US Claims Tribunal, as well as claims commissions such as the UN Compensation Claims Commission or the Eritrea-Ethiopia Claims Commission. However, it would be fair to say that there were still relatively few decisions on interstate reparations. So things are quite different today, for almost 25 years later. We are in the midst of a significant rise in the judicial and arbitral decisions on interstate reparations. Example, before the International Court of Justice, cases such as Diallo or certain activities or armed activities, most recently, between Democratic Republic of Congo and Uganda. In the interstate context, be that Dusgood arbitration between Malta and São Tomé, Arctic Sunrise between the Netherlands and the Russian Federation, or before International Tribunal for the Law of the Sea, in the case of North Star between Panama and Italy, or cases such as Cyprus against Turkey before the European Court of Human Rights. These cases have arisen in respect of very different areas of international law, with significant differences in terms of the nature of the breach and the types of injury caused. So throughout the next hour or so, we will seek to understand the ways in which international courts and tribunals have grappled with customary rules on reparations, as reflected in the ARSIWA, as well as the gaps or salient features where developments are still very much needed. While we will focus our discussion on interstate reparations and decisions by courts and tribunals in this context, towards the end of our discussion, we will briefly touch upon the ways in which the same principles of the ARSIWA have been used so far by dispute settlement mechanisms that deal predominantly with disputes between individuals and states, such as in the context of ISDS or regional human rights mechanisms. So our discussion will take a form of a fireside chat rather than standalone presentations. And we should have plenty of time towards the end to have a discussion with our audience. So please do make sure to write your question in the Q&A box as we go along, and if possible, indicate whether the question is addressed to a particular speaker. So without further ado, let's kick off. And the first section of this discussion, I propose for us to set the scene for our audience and for the further discussion. So to do that, I propose a very quick sort of question, a teaser question to all of you. What do you think has happened that may explain the rise of decisions by international courts and tribunals on interstate reparations? And perhaps without any particular order, I would start with Christiane. What do you think? What do you think has happened that suddenly we are seeing many more of these decisions coming from courts and tribunals?
Thank you so much, Vlad, and thank you for convening us. Thank you for the kind and comprehensive introduction. I actually think you should be on this panel because Vlad knows at least as much as we do on this particular topic, so we couldn't have a better moderator. I mean, to answer your question briefly, I think it's been a long time coming that we see more of these decisions. An obvious explanation is the growing institutionalization and judicialization of the international legal order, which leads to a deeper legalization. I still think that the term rise of decisions is relative in this context. There has been an increase of decisions for sure on interstate reparations, notably at the ICJ and ILC, as you said. But the cases in the pure interstate context remain much more limited than what we see in mixed disputes between states on the one hand and individuals and corporations on the other hand. So in 2017, actually, the UN Secretariat conducted a numerical analysis of the references to different provisions in the ASIWA in decisions of international courts and tribunals since 2001. And the ICJ referred to Article 36 on compensation 15 times without necessarily awarding compensation, whereas arbitral tribunals in publicly available awards referred to the provision 40 times. And if you look at more recent compilations prepared by the Secretariat regarding decisions referring to the ASIWA, the trend really looks very similar. So I wonder, and I'm putting this out as a question for discussion at the very beginning, whether the award of compensation in such mixed disputes has had an effect on international courts and tribunals dealing with interstate claims. Put differently, considering the practice of arbitral or human rights tribunals regarding reparations, states might put greater trust in international courts and tribunals to award compensations, especially if prior political negotiations have failed, like in the armed activities case.
Very, very interesting. And I think it's a good ground for what maybe other speakers would like to say on this first teaser question. Alicia, do you have something to add to what Christiane has just mentioned?
Yes. Well, first of all, thank you very much, Vlad, also on my part. And I second everything that Christiane has just said about you and the event. More in general. So to add to what Christiane was saying, I think from my perspective, it is difficult to say whether this apparent increase in the number of decisions of interstate reparation claims is linked to structural changes of the international legal order, besides the changes that Christian has just mentioned. So I will just limit myself to make an observational point. I think what is very interesting is that there seems to be a clear trend in pursuing more reparation claims in interstate cases that are the result of international crimes of states. So from 2000 and onwards, there is definitely this trend of cases before the European Courts of Human Rights, International Claims Commissions, the ICJ, with the armed activity and the Bosnian genocide, which shows that interstates and the international community as a whole wants to make sure that states violating rules pertaining to the breaches of the prohibition of the use of force, genocide, occupations are accounted for this crime. And I think this is very interesting.
Absolutely. Very, very pertinent observation. And we will get more in detail to the question of the nature of the breach and how that impacts also the determination of reparations. Yusra, would you have anything to add to this?
Yes, thank you so much, Vlad, for the kind invitation. I'm very happy to be here and to share some thoughts on this topic. And I think my reflection, I feel, complements what Alice said really well, because I've also observed that it is more in this context where individual harm is involved that we are seeking to hold states accountable and seek reparations. And that's not really a coincidence if we steer away from our traditional kind of doctrinal lens through which we examine international law, and we look more at increasing social science studies that have demonstrated the grassroots or local movements that actually push states to enter into disputes with other states in pursuit of reparations, and specifically of interest for those individuals would be compensation. So many of the interstate cases that we are currently seeing, or that might actually arrive at a point of reparations and compensation. And I'm thinking particularly before the European Court of Human Rights and the interstate model there. I think this can be explained by, to a certain degree, states feeling a sense of pressure to respond to the population's demands and to show them that they are acting to seek redress. And so they turn to courts, which are, public forums of accountability.
Absolutely. And maybe one little point that I would add is, if you just look at some of the recent cases decided and decisions delivered by courts and tribunals, you see quite a huge discrepancy between what the claimant was requesting and what ultimately the court delivers as the final sum. And this maybe is a reflection of what Christiane mentioned, that claimants are trying to really come up with superbly high numbers, and then they fail to actually, end up negotiating, which would be the usual approach, and to which we are used. The court delivers a judgment on the merits, even if says reparation is due, up for the parties to negotiate it. But when we see this huge discrepancy, and just to give an example to our listeners, in one of the most recent decisions in the armed activities, DRC was seeking over $13 billion of compensation. It ended up getting $325 million of compensation. So perhaps a food for thought. But actually, this brings me to something else, Yusra, that I would like for you, just for the sake of our audience, to recap quickly. What do the articles actually say about the obligation to provide reparation, which is still very much the chief legal, not the only, but the chief legal consequence that flows from an internationally wrongful act?
Yeah, I agree with you, Vlad. And I actually think that you summarized it beautifully at the beginning of this webinar, so I won't add too much. But yeah, I think using the word chief is really key. I think that we tend to forget actually that the ARSIWA was historically conceptualized with the goal of providing reparations, and that's somehow been, I think, lost in more theoretical and practical interest in other aspects of the ARSIWA, which are also important. But this is really what historically justified its drafting, and would distinguish it from other provisions. I can think of Article 60 of the Vienna Convention of the Law of Treaties, which talks about consequences of a material breach. But there we're talking more about negative reciprocity where a party can't be expected to respect its obligations under a treaty if the other party refuses to honor them. But here we're really talking about something else, which is what do I get for this breach and this act that has impacted me. So Article 31 of the ARSIWA clearly states that the responsible state is under an obligation to make full reparation for the injury caused by the Internationally Wrongful Act. And I think there are two key things to point out here. One is the term full reparation. You mentioned this earlier. There is a requirement to really wipe out all the consequences of the illegal act, reestablish the situation which would have existed if the act had not been committed. But I think there is increasing criticism in scholarship, especially about whether this is actually feasible, whether courts have actually managed to respect this. And then the second aspect is the term injury, which the ILC interprets very broadly, and it states in its commentary that it's left to the primary obligations to specify what exactly is required. So interestingly, there's no requirement of damage to a protected interest for a state to be entitled to seek reparation. But if there is damage, then this can be material or moral. And I think the fact that there's no requirement for damage maybe can raise some complexities when it comes to quantifying the quantifying act for the purposes of determining compensation in a relevant case.
Right. So the definition of injury still provided either material or moral damage, and then we get into the territory as to how do you quantify the damage. But just on the conceptual point, there is obviously another element, which is that of causation, and which is also there in Article 31. And again, just for the sake of, in an interest for our audience, Alice, maybe you could just take this further and just recall to us what different forms of reparation are actually envisaged under customary international law as reflected in the articles. And more specifically, particularly looking at the period post-2001, does the practice of courts and tribunals suggest that there is some sort of hierarchy or clear order between them, or has it been done sort of on a more ad hoc basis so far?
Yes, so the Articles on Responsibility of States for Internationally Wrongful Act identify three main forms of reparations: restitution in integrum, compensation, and then satisfactions. And these are all considered widely as reflecting customary international law. And indeed, if we take a look at the compilations that is done by the General Assembly every 2 years that regards decisions of international courts and tribunals that refers to the state responsibility articles, Article 31 to Article 37 are often quoted as reflecting customary international law. Now, this provision and also the commentary to these provisions suggests that there is indeed an order and perhaps even some sort of hierarchy in the forms of reparations to be granted. So compensation shall be given insofar as damage cannot be made by good by restitution, and satisfaction shall be taken into account insofar as the injury cannot be made good by restitution and compensation. However, it is interesting that if we look at the practice of international courts and tribunals, there is much more flexibility. So as a pure matter of facts, one may consider that, for example, despite the apparent primacy of restitution, compensation is by far the most sought and awarded form of reparation. But more interestingly, in my opinion, and from a more legal perspective, the way in which courts and tribunals decide on the type of reparations to be granted does not necessarily follow the order of ARSIWA. And I think a good example is satisfaction. So in the articles, satisfaction is envisaged as a residual and exceptional form of reparations that shall address basically moral and non-material injury caused to the state. Yet in the practice of international courts and tribunals, sometimes satisfactions, especially in the form of declarations of wrongfulness, rather than being used as a residual remedy to restitutions and compensation, is used as an alternative to them. So it's not necessarily a form of redress to moral and non-material damage to the state. It may cover other damages. And I think an example, I think we might look at the genocide case in 2007, also from this perspective, when the courts awarded satisfactions to Bosnia in relation to Serbia's breach of the obligations to prevent genocide. So one might argue that the court did not award satisfactions because it deemed that Serbia had not caused material damage in Bosnia. Serbia had definitely contributed to the occurrence of genocide by failing to prevent, but being the court unable to establish the causal link that was sufficiently direct and certain, the court opted for awarding satisfaction as an appropriate kind of remedy.
Right, it's just very much a common approach of international courts and tribunals dealing with interstate cases to come up with the best solution in the form of declaratory judgment, saying this is perfectly sufficient as an adequate satisfaction. But I do take your point that sometimes the borderlines between different forms of reparation are not so clear-cut, in particular where the claimants themselves do claim as separate heads of damages and compensation for those heads, and then in parallel monetary awards as a matter of satisfaction. So that may, start ringing bells for a judge, because ultimately what the judge operates is in full conscience that we cannot allow for the overall amount and the form of reparation to get into the remits of what would be some sort of punitive damages, which clearly are not allowed under international law. So to pick up on this, and maybe the last point in this section of our discussion, Christiane, what do you think are really, in sort of conceptually on a general level, what are the greatest challenges or unknowns or aspects which remain still very much insufficiently tested or developed in the existing legal regime on reparations as far as courts and tribunals are concerned?
Well, that's a difficult question, because I think there are many. But let me start answering that question on a conceptual note, maybe picking up a little bit on what Yusra said. To understand the provisions in the ARSIWA on reparation, it is important to see them in the overall framework of international responsibility. In particular, I think it's important to understand that Part 2 of the ARSIWA on reparation is a bit of a stepchild of Part 1 on the Internationally Wrongful Act. So as Yusra explained, responsibility arises without the occurrence of damage. But that was a deliberate decision by the ILC. So by omitting damage as a condition of responsibility, the ILC made the law of international responsibility more objective. Responsibility arises based on the breach of an international obligation and attribution of conduct, the two elements of the Internationally Wrongful Act. And in the context of this change, the provisions on reparation in Part 2 of the ARSIWA have also been modified. From the rights of the injured state, the focus shifted more towards obligations of the responsible state in the ARSIWA on second reading. The ILC actually conducted this shift without having a lot of practice on compensation or reparation at its disposal generally. As Special Rapporteur James Crawford noted in his third report on state responsibility at the time, he says, there have been relatively few recent awards dealing with the assessment of material damage as between state and state, i.e. outside the field of diplomatic protection. Crawford actually therefore cautioned against the laying down of detailed rules on compensation. So in a way, the existing regime in the ARSIWA is somewhat rudimentary conceptually and in view of the practice available at the time of drafting. Now, to answer your question, Vlad, there are quite a few challenges, as I said, in the existing regime, which the practice after the adoption of the ARSIWA made clear. And I will only flag those challenges at this stage because I'm sure we will go into greater detail on many of the issues later in the discussion. So notable areas of clarification include, I would say first, and that was just addressed previously by Lice, the relationship between compensation and other forms of reparation. And I would add that different international courts and tribunals might also use their own terminology for the different forms of reparation, which is notable in the human rights field. Second, and you already mentioned that too, causation, which figures prominently in several provisions of the ARSIWA and is particularly important for compensation. And in this context, it would be important to distinguish between factual causation and different standards of legal causation, which might depend on the underlying primary rules. And another aspect that deserves clarification is damage caused by multiple actors, which could lead to shared responsibility. A third challenge is actually the calculation of interest. Article 38 of the ARSIWA was only added on second reading. On first reading, the award of interest was as part of the provision on compensation. And fourth, the law of evidence, particularly the question of burden of proof and the rule of experts, which played an important role in the armed activities reparations judgment. To conclude, maybe I should note that most of these issues are on the radar of the International Law Commission, because in 2016, the ILC Secretariat published a working paper on possible topics for the ILC's long-term program of work, and both compensation under international law and principles of evidence in international law are on the relevant list. Thanks.
Fantastic. This is a very nice and comprehensive sort of platform for us to try to scratch a little bit deeper under the surface in terms of the existing legal regime, but also the reasoning and some of these decisions that I mentioned earlier in my introductory remarks. I think it would be fair to say that today, when we look at some of this most recent practice, the articles are often the sort of the starting and the end point of any discussion on reparation and the reasoning of courts. But maybe I would still stay with Christiane for a second and just wondering whether it would be fair to say that the courts have broadly applied and interpreted the law in this area in line with what the articles say specifically, or their commentaries, or have we seen any clear examples where the courts may have deviated from what the articles say in either the provisions or the commentary?
Okay, thanks. Just unmuting myself. Yeah, thank you for that question, which follows up nicely with what I just said about the origins of Part 2 of the ARSIWA and its drafting history. The ARSIWA are a general framework. I think we all know that, and therefore they leave a lot of wiggle room for international courts and tribunals. They're meant to be a lex generalis. So put differently, the ARSIWA are a fallback option, and the ILC was aware of the possibility that practice would develop, especially regarding Part 2. And in general, actually, the ILC commentaries on many topics are often kept fairly broad to give room for different options, particularly if the law is not entirely clear. Therefore, I would not say that practice significantly deviated from the ARSIWA, but that international courts and tribunals have used the broad statements and the commentaries to the ARSIWA to develop their own rules and principles on compensation. So in this context, a reference to the ARSIWA might then serve as a hook to give legitimacy to the decisions of those courts and tribunals, to then come up with more detailed statements and idiosyncratic findings on compensation. So for example, in Diallo, the ICJ only referred to the ILC commentary to Article 36 briefly to support its finding that no compensation can be awarded for Guinea's claim relating to unpaid remuneration following Mr. Diallo's expulsion. Or in armed activities, the court cited the commentary to Article 31 of the ARSIWA when finding that some of the lives lost during the conflict may be regarded as having a cause that is too remote from the internationally wrongful acts of Uganda to be a basis for a claim of reparation against it. Same picture really in certain activities. The ICJ referred to the commentary to Article 38 of the ARSIWA for confirmation of its statement that interest is not autonomous is not an autonomous form of reparation, nor is it a necessary part of compensation in every case. And then just to look at a different tribunal, maybe in the North Star case, the International Tribunal for the Law of the Sea noted that Article 36, paragraph 2 provides that compensation shall cover any financially accessible damages, including loss of profits, insofar as it is established. And as you can see here, these are fairly general references to the work of the ILC, which is being used to support more case-specific conclusions. So it would be hard to say there's a real deviation from what the ILC gave to us as a standard at the time.
Absolutely, I couldn't agree more. There's some sort of organically developing jurisprudence, and sometimes courts and tribunals do pick up on these general pronouncements, but try to come up with a more specific application thereof. So another example in the context of causation is just how out of the blue the ICJ picks up a particular standard, a particular approach to the required causal link in 2007 Bosnia genocide case, and puts out black and white that the link which is required is a sufficiently direct and certain causal link, and then sort of plays in its further jurisprudence with the same standard, which is nowhere set out in the articles as such, but then sort of minimizes the idea that this would be the standard applied in all and every circumstance, namely, that is exactly what the court did in the certain activities and in the armed activities case. So you can see how sometimes the very same court may over time play with a more precise formulation or application of a particular rule, and so there are some really good examples, I think, where we could juxtapose what the articles do say and how the courts actually use them. But on that, to what extent, if any, and this I'm turning now to Alice, have courts and tribunals, or should they take more clearly into account the nature of the breach? You mentioned earlier in your comment that we see many of these issues arising in the context of the most serious violations committed by states. And so I wonder, because these are really intrinsic characteristics which have to be taken in the context of determination of reparations, namely the breach and the nature and extent of the injury. So I wonder, do you think like courts and tribunals have been doing and have been taking these factors thoroughly into account?
Well, I think, Vlad, this is a key question, is a key point, and I think it touches mainly upon two very broad themes. So one would be causation, and it is very much was Christian mentioned before. So the idea that causality might be, and the standard of causation might change, and courts may adopt different standards depending on the nature of the breach of the underlying internationally wrongful act. But I will stop on this point. Maybe we will have time to dig on it later on when we speak more about causation. And there is another theme that is linked to what I said before. So the idea that depending on the type of a breach, the underlying wrongful act, and the extent of injury, also the forms of reparation may change. And let's start by saying that this idea that courts and international tribunals could or shall develop different forms of reparation depending on the underlying international wrongful act is something that has already emerged in the practice of international dispute settlements involving individuals. So the jurisprudence of the Inter-American Courts of Human Rights, but also the case law of the ICC are good examples of how courts may differentiate in types of reparations depending on the underlying internationally wrongful act. As per interstate practice, I think things are much more blurred. So there is, on the one hand, a timid tendency to move towards this direction. If we take recent environmental cases before the ICJ, pulp mills, for instance, Costa Rica versus Nicaragua, Nicaragua versus Costa Rica, the court seems to have progressively attached restitution and compensation to damage that are caused by breach of primary substantive obligations, such as the obligations to prevent environmental damage, whereas the violations of procedural rules only entails satisfactions in the form of declaration of wrongfulness. But as I said, this is a very timid tendency, and it is a slow process which is not devoid of incoherences and also missed opportunities. And I think the arm activity case was probably a missed opportunities in that sense, because in that case, among the types of reparations that were asked by to Uganda in relation to the consequences linked to the violations of the use of force, there were also the requests to conduct criminal investigations toward Ugandan military forces responsible for the violations of human rights and humanitarian law, and pecuniary satisfactions to be used for promoting acts of reconciliations between the two parties. And yet the court rejected this request. And I think it was regrettable because it would have been an opportunity for the court to underline, for instance, the importance of the primary rules violated and therefore the violations of jus cogens rules and grave breaches of the use of force, and also to highlight the exceptional character of these violations.
Fantastic. So this clearly means that these two criteria remain very much relevant. And if I think maybe if something that one can extrapolate from reading the reasoning of the court in the armed activities is the more diffuse and the more expensive in the sense of scope the injury, the more difficult for the court to actually accept it. You know, you look at allegations of macroeconomic damage as a result of protracted armed conflict. Well, the court clearly seemed not very interested in getting into those kind of injuries and any appropriate reparation which should ensue for that. So anyways, a lot to take into account, and I particularly liked also your distinction in the environmental context, whether what we are seeing right now is sort of this procedural versus substantive, and whether that has a particular impact on the actual reparations awarded. So these are two criteria which we can all agree safely that they are relevant for the purposes of determination of reparation. But let me just turn now to the other side, Yusra. There seems to be other things that at times courts and tribunals are either expressly or impliedly conscious about, and to what extent they should take considerations which are extraneous to the link between the Internationally Wrongful Act and the injury caused. So to give a very concrete example, there has been quite some discussion propelled namely by a fantastic article by Martins Paparinskis on the capacity to pay and on the excessive awards that we see in some context where states are actually unable, you look at the GDP of Uganda and you put yourself a question, well, if we were to award what DRC had asked, the 13 billion, well, the entire country would not be able to continue functioning anymore. Or other considerations such as who are the beneficiaries of reparations. Do these considerations come into play before judges? Should they come into play more squarely? So this is a question for you, Yusra. What do you think?
Yeah, absolutely. Really timely questions, I think. Yeah, so let's take the first example you gave about the capacity to pay. The International Law Commission actually excluded from its draft and commentary anything alluding to crippling compensation, as you mentioned. Martins Paparinskis refers to it, right? And really just presented full reparation in its entirety without any specific caveats or exceptions or allusions to that issue. And this is different from, for example, restitution or satisfaction, where there are actually some caveats against excessiveness. But James Crawford himself actually said that this was a bit of a trivial matter. But I actually think that in recent case law, we can see that that's actually really not the case. So if we look at, investor state arbitration, if we look at the European Court of Human Rights, the famous UCOS case, or as you mentioned, Vlad, DRC versus Uganda, I think that even the $325 million will still, undoubtedly impact Uganda's economy, right? So I think that this is something that courts consider, but I wouldn't say that we're at the point where it is a customary obligation of any kind, and this can be explained by just there aren't that many of such opportunities that have come up for courts to pronounce themselves and to refer to this. But it has been a long-standing consideration. If we go as far back as the Treaty of Versailles in 1919 did mention that, the resources of Germany are not adequate to make complete reparation for all loss and damage. The UN Compensation Commission did refer to the economic capacity of Iraq, so that was taken into account. The Eritrea-Ethiopia Claims Commission as well. And interestingly, in the DRC-Uganda case, the ICJ did refer to the Eritrea-Ethiopia Claims Commission, and it referred to that commission's consideration about whether in determining the amount of compensation, account should be taken of the financial burden, but it didn't actually say whether or not that was, applicable in this case or a part of its consideration. It did, however, say we're satisfied that Uganda can pay this, right? So I wouldn't say that we're at the point where this is a custom, but I do think that it's something that courts consider. And you raised another example of the ultimate beneficiaries of reparations. So absolutely, I actually think that this is the most poignant in diplomatic protection cases. So Diallo, which was mentioned earlier, is a good example, where the real injury is obviously the individuals, even though we have this famous, Mavromatis fiction saying that it's the state. And in the ILC, this was a huge matter of debate when they were developing their draft articles on diplomatic protection, right? And it did not amount to any kind of concrete assertion that the reparation should be given to the individual. It was more of a, in Article 19 that this is encouraged, the state is encouraged to give the amount. But certain judges, for example, Judge Yusuf has been quite publicly critical about this, and a lot of scholarship as well. And I think the same can be said about mass claims such as DRC Uganda. I think that, hopefully we'll get to talk about this later on, but the methodology that was employed, I think, can raise a lot of questions about, are the ultimate beneficiaries really, getting what they wanted? So I'll stop there.
Right. So let me just pick up on what you have been explaining, and particularly Christiana's earlier point on the sort of the areas that need improvement. And let's take a concrete example of the three latest decisions of the ICJ on interstate reparations. And I think there, when you read carefully the reasoning of the court, at times you kind of have an impression that this is a little bit more of an art than actual law, in the sense of there is some passages which you can see what the French like to say, du flou artistique, or artistic blur. And I think it would be fair to say that that comes most prominently on three aspects. One, the so-called use of equitable consideration, which is the approach that the court seemed to embrace in the post-Diallo analysis of any interstate reparations. The second one is what the court came up most prominently in the recent armed activities judgment, the so-called global lump sums, and the third one obviously remains causation, because while the court sort of seems to slowly move away from its very clearly defined setting in 2007 Bosnia genocide judgment, we still see that there is some level of incongruity, particularly the court sort of a priori distinguishing different legal situations in which breaches occur, and hence that allowing for that to have an impact up to the extent of presuming causation in the context of Ituri, which was occupied territory, or taking specific inferences in terms of evidence and in terms of, in particular, burden and standard of proof. So I wondered, are these issues really posing a real challenge to the legitimacy of the decisions which are delivered on reparations, or are these really just sort of secondary things which which we can deal with somehow more pragmatically. So I would like to hear from all of you, and maybe I can combine that with another reflection, which we saw in particular in the certain activities and the armed activities case, which is the court going out there in the armed activities to seek expertise, including on the methodology for the evaluation, for the quantification of damages. And so has that approach really been useful? So maybe combining that, and in no particular order again, but maybe we should kick off with Christiane, who had laid the ground early on this.
Sure, happy to take this again difficult question of legitimacy, which I think it's a tricky concept in any context, but it's a really good question. And I think that the question of legitimacy of international courts and tribunals regarding reparations, it does depend on the field of law and the interests of at stake that we are considering. And this very much relates to what Yusra and Alice have said earlier about the court going more in the direction of protecting human rights and the environment. But let me make a more general point on the legitimacy first, and the point about interests at stake. I would like to distinguish, I think, here between input legitimacy and output legitimacy. As for input legitimacy, the ICJ stakeholders are the parties to its statute, and that may appear before the court. But as for output legitimacy, it is a bit more complicated. I would say we could distinguish between like a narrow circle of stakeholders and a broader circle of stakeholders here. In the narrow sense, the court stakeholders are the parties to the dispute, but in the broader sense, the court might also be aware of its role in the international community and its role in maintaining the international rule of law more generally. So the interests at stake here are community interests. And all of the three decisions that you just mentioned regarding reparations in the past decade somewhat concerned those broader community interests, notably the protection of human rights and the environment. This was the case ultimately in Diallo, even though I agree with Yusra that, obviously some would say this was the state that was injured. In armed activities, we had large-scale human rights violations, and in certain activities, we had the protection of the environment. And despite the differences between those three cases, the ICJ has actually interestingly created connections between them by applying the same principles and considerations, which might indicate that the court itself is satisfied with this overall approach, and that it thinks that the approach is itself acceptable to states and the community at large. In this context, it might also be interesting to note that in Cyprus versus Turkey, before the European Court of Human Rights, that court also referred to equitable considerations. And those play a particularly important role in situations of non-pecuniary damage and then just satisfaction for that damage. I think it is interesting to contrast those cases again with actually compensation awards in investor-state disputes, where the calculation of compensation is much less of an artistic blur, as you said. Arbitral tribunals typically justify much more precisely why and how they award compensation, including specific methodologies. I don't think we have time. What's the purpose here to discuss those methodologies? But let me just note that there are also issues in arbitral tribunals regarding the calculation of damage. So, for example, the practice has shown that there are significant divergences on the determination of lost profits, the choice of interest rates, for example, the application of simple interest, compound interest, and diverging experts' views. But now, circling back to the question of legitimacy, these tribunals do not serve community interests, but the specific interests of the parties to the dispute, and by extension, the parties to the International Investment Agreement. And that might explain why they are much more detailed on compensation awards and don't speak about global sums as the ICJ would do in cases of human rights and environmental protection.
This is excellent, Christiane. I really like this sort of distinction between the input and output legitimacy. Yusra, do you have something to add here? And then we can maybe add with Alici, who might tackle more directly the expertise as well question. Yusra?
Yeah, well, I agree with Christiana that legitimacy is a very complicated term. It's one that I've really grappled and struggled with myself in the writing of my book. There's so many different standards that it can be based on: justice, fairness, democracy, so many other aspects. So I acknowledge that in the response that I'm going to give. That's an important caveat to make. I still consider that that the methodologies applied by the ICJ. So if we're thinking about the global lump sums, for example, I would say that this does actually impact the legitimacy of the court, because this methodology it just lacks the necessary accuracy and therefore the individual acknowledgement that these people have sought to begin with, especially when human suffering is concerned. And I think that, going back to what Christiana said about the stakeholders involved, so I do agree that there are two circles, but I do think that the ICJ should serve broader stakeholders. I think for better or for worse, it has been pulled a lot more into this context of international community and community interest, and has seen as some kind of a guardian. One author said a reluctant guardian, but a guardian nonetheless. And I also think that there's a famous adage that law does not exist in a vacuum, right? I think courts do not exist in a vacuum. I think that despite the ICJ being an interstate court, I think that a consideration for these populations can be expected in an international legal order that is increasingly characterized by the variety of actors within it, and especially if we consider that, you know, such individuals have a perception of international law where it's a tool for them to overcome some kind of an imposition by a more powerful force. That's their perception of courts, right? Again, really well documented in social science studies outside of international law. I do think that should, you know, be factored in. What's interesting is that the court has said, both in Diallo and in DRC, if we take those two cases that I referred to earlier, that it's a lack of evidence, the absence of evidence, that has resulted in this lack of consideration for individuals, that if only there were enough evidence, then, you know, maybe the court could have done a better job or been more accurate. And so it's interesting to think about the role of evidence in that respect, as Christiana mentioned earlier.
Definitely in cases of protracted armed conflicts where, you know, you give a judgment on the merits in 2005 and hope that the parties will agree among themselves outside the court as to what should be the actual reparation, and then they come back to you 15 years later, and, you know, where evidence is not preserved, and how do you proceed? On the one hand, you are a court of law, you have to show the reasoning, the legal reasoning. That is what directly impacts your legitimacy. But at the same time, you're sort of between a hard place and the wall, where you are like, well, there have been some of these violations, they have occurred. In fact, myself, the court, I have so established in 2005, you know, so this is a kind of a tricky area, and where the court, I think, has to play with some means that it has at its disposal, namely standard burden of proof, to what extent there should be a shift in some of these traditional approaches in the context of interstate reparations, and that's precisely what we kind of saw in action in the judgment. Alicia, but I wonder on the methodologies, and maybe like to sort of stray into that area. Do you think that the experience, you can obviously say to other things, but do you think the court's experience has been, you know, satisfactory thus far?
Well, it depends, I would say. And let me just add maybe two things about that relates to methodology and relates to causality and the role of experts. So as for causality, well, you, Vlad, are the expert on this, but this is really probably one of the most thorny issues for courts to address when they establish reparation cases. And I think that the armed activities reparation case clearly pointed this out. And there are 2 points that I want to stress. One is the struggle of the court in distinguishing, and this was something mentioned by Christiane at the very beginning, between factual causality and legal causality. And this was the problem for a court, because at the end it resulted in obscure, if not confusing, reasoning. So the court makes, as you said before, several times the statement that causality may depend on the underlying primary rules, the extent of the injuries, but at the end of the day, it's just a statement of principle, because the court, except for the Ituri district area, and I will have some criticism to point on that as well, but except from that area, at the end, the courts adopted the very same standard of causality throughout the entire decision. And the second point of criticism that the court and the ICJ, but more generally courts, will have to address at some point is the problem of overdetermination. So far, causality have proved particularly complicated when courts and tribunals face situations in which damage ensure from an international wrongful act, which is the result of concurrent and cumulative causes. And again, the armed activities reparation cases provided an exceptional opportunity for the court to address these points, distinguishing between cases in which 2 armed forces are involved, cases in which there is a state and a third party involved, but the court skillfully refrained from addressing this issue. And then on methodology in relation to expert. So I think this is also like the relationship between the court and experts appointed by courts is very delicate, and there is a complex balance there. Now, there are cases in which recourse to expert by a court or a tribunal is warranted, mainly because of the highly technical and the scientific questions that the court needs to address in order to allocate damages. And I think in these cases, if the court shies away from addressing this issue with a scientifically sound methodology, this might expose the court to criticism. And this is exactly what happened in 2018 with the Costa Rica versus Nicaragua compensation case, where the court decided not to rely on expert, as it had done at the merit stage, but at the same time, neither opted for equitable considerations, which would have allowed the court to use purely legal criteria to define the matter. And instead, it opted for its own methodology, which might sounded not scientifically sound enough. And that exposes the court to criticism. At the same time, and with this I'll conclude, when appointed to answer to technical questions, I think the problem is that experts may also move within an epistemic framework that at times is very different from the framework in which judges operate and develop their legal arguments. And so this means that there might be cases in which the outcome of the expert evaluations does not match the expectations of the court. And the court may seem unreasonable, the outcome. And again, this is what happened in the armed activity case, where instead the court resorted to expert. But the outcome of the expert opinion was seen by the court unconvincing. And at the end, we might say that this was an even greater burden on the part of the court, because at that point, the court had to justify why it decided to depart from the outcome of the expert and move towards another direction.
And it's interesting to notice that many judges in their individual capacity and the opinions attached did seem to quite sort of regret the fact that the methodology adopted by the experts was clearly not appropriate on some hands of losses, but then at the same time regret that the majority of the court didn't take an extra mile to justify what methodology they ended up adopting and just using the sort of the global sums approach. And Judge Tomka was one of those voices in criticizing the majority. So, okay, so now towards the last sort of 5, 6, 7 minutes, I wonder, we seem to agree that apart from these specific angles and areas, we have a functioning fallback default regime for reparations out there. But would you say that broadly states are happy with the regime as it is? And maybe I will turn to Christiane for that one. Or is there some sort of backlash going on that states feel like, no, this is really what courts and tribunals are doing is really not quite what the law is?
Yeah, thank you, Vlad. Again, challenging questions. Is this the best we can get from states? Are they happy? I mean, if this question is geared towards improving the ARSIWA, I think the current state of the play is that the Sixth Committee won't move on making a treaty anytime soon. I think we can say that. As for improving or making changes by state practice in the absence of a centralized lawmaker or the International Law Commission providing some more guidance on the issues we've discussed, the practice will inevitably be inconsistent. And we can see that again in the area of investor-state dispute settlement, where compensation is being calculated based on different methodologies, different ways. Let me just say that at the general level, like at the level of general international law, I think it is important to have some flexibility, and states are generally happy with that. Many disputes are resolved at the political level before they reach international courts and tribunal, and this is probably a good thing. It saves money, but more importantly, it fosters good political and economic relations. But states have become increasingly unhappy with the existing regime on compensation in actually investor-state dispute settlement, as you know, precisely because the practice is inconsistent and has led to unpredictable and in some cases unacceptable outcomes. Yusra already mentioned crippling compensation, and you mentioned that too, Martin Sparkarinsky's article. So as you will also know, the Working Group 3 of the UN Commission on International Trade Law, UNCITRAL, is currently working on an ISDS, investor-state dispute settlement reform. And regarding compensation, the Secretariat of UNCITRAL identified 4 issues, particularly the complexity and uncertainty of current practice, high amounts of compensation and increased amount of claims. So that's the same issue we've actually noted regarding the armed activities case. Then third, a means to address discrepancy between claimed loss and awarded damages, including excessive claims, and divergence of expert damage calculation. So again, we have this real overlap with what we also see in the interstate context. We don't have time here, I think, to look at each of these points in detail, but I think it's important to acknowledge that many of these arbitral tribunals actually apply the ARSIWA, and that maybe the solution might be found in common reforms. Although UNCITRAL is the ILC's sister institution and is also a subsidiary organ of the General Assembly, its members are actually states and not individuals. So it remains to be seen whether UNCITRAL will propose some reforms on the rules on compensation, which might then have a spillover effect on the work of the ILC. So this is definitely a space to be watched.
Fascinating. And that it sort of brings us very nicely into the sort of the last part of this discussion. How can this common regime that we know, how does it irradiate to different specialized regimes? And so you mentioned in quite some detail what is happening at the moment in the context of ISDS, but I wonder what is the approach of other dispute settlement mechanisms that deal more specifically with cases between individuals and states? And here I'm thinking in particular about the 3 regional human rights courts. So I wonder, maybe Yusra can take a quick take on the European Court and the African Court of Human Rights, and Alice on the Inter-American Court, just to kind of juxtapose. Do we see these jurisdictions simply picking up the same ARSIWA principles, or they are slowly for their practice modifying them slightly?
Right. Yeah, I think it's a great question. I'll probably start off just by specifying or clarifying rather that the European Court of Human Rights does apply the ARSIWA, just because there's been a fair amount of scholarship disputing this and saying that actually the 2 regimes have nothing to do with each other. But there have been a clear number of cases where the European Court has explicitly applied the ARSIWA, and there's even a case a 1995 case, the Papa Michalepoulos case, where specifically talking about reparations, the European Court cites the factor of Chaozhou PCIJ judgment and specifically talks about the need for full reparation. And, so they are not incompatible. But I think what's interesting is that the European Court of Human Rights, despite it being a human rights court, is perhaps a little bit more similar to the interstate courts we've been talking about than I am happy to admit, according to my research. So the European Court of Human Rights is no more transparent about how it comes up with certain, sums or values, how it quantifies certain things. Than the ICJ, for example. And another really surprising aspect that has come out of Veronica Fikfak's research in particular is that she argues that actually the court's method is not particularly individual focused. So she says that the European Court will typically look at the applicant's loss, so whether the victim has suffered psychological harm, distress, humiliation, etc., and the likes, and it will look to all the circumstances of the case to do this. But her research shows that it's actually unclear whether any of this affects the level of compensation, so whether it weighs in, which is really fascinating if we just think about the fact that it's a human rights court, right? And I think, Vlad, you also referred to the African court. I think we'd also expect that the African Court of Human and People's Rights would have exemplary practices in this area when it comes to mass claims, just because jurisdictionally it is the most receptive of the regional human rights courts in particular to collective rights, collective harms, communities. Actio popularis is completely accepted at the African court. So for all of those reasons, we would probably expect there to be more clear case law in the realm of reparations for mass human rights claims. But actually, that's not exactly the case. Of course, we can't compare the number of cases that have even reached that level before the European Court and the African Court, for example. So that's part of the explanation. But the African Court itself has expressed a little bit concern about the difficulties relating to making those calculations and, more broadly speaking, dealing with reparations, mainly because it has stated because of the large number of individuals that it has to take into account, but also because of issues relating to evidence. So I feel like for a lot of courts, this is a similarity where it comes back to this issue of, having enough evidence, having the appropriate evidence, and being able to come to appropriate conclusions. But I do think that, for example, I know Alicia will touch on this, but I do think that the Inter-American Court, for example, has perhaps some better practices, and the International Criminal Court as well. And I think that, more broadly speaking, I can imagine that as the practice of reparations continues before all courts, there has to be a lot more of cross-fertilization, communication, looking to see what other courts are doing and borrowing best practices.
Thank you, Yusra. Alicia, what about
Yes.
Inter-American?
Yeah, so I'll be very brief in this interest of time. So as I mentioned at the very beginning, and as Yusra has just mentioned, the Inter-American Court of Human Rights is known for having developed creatively a broad spectrum of forms and type of reparations, which includes more classic form of reparations, such as monetary compensations, but also rehabilitation process, symbolic reparations, ceremonies to honor the victim, for instance, various forms of guarantees of non-repetitions, and to be provided reparations not just for individuals, but also to collective entities, and to recognize both direct and indirect victims. And one point which I find very interesting is also to look at how the court is developing its own jurisprudence of human rights and the environment. Because it seems that the Inter-American Court is adopting an approach of reconstructive reparations. So it's shifting from a retrospective approach of determinations of the wrong caused by non-material damage to a future-oriented framework of constructive redress. And I think this is very important when we think about the increase in interstate dispute settlements in relations to the environment, but also if we think about, for instance, the request for the advisory opinion on states' obligations of climate change, since the court was requested there to express also on the legal consequences of states' violations of their climate change obligations in relations to present and future generations. So this might be interesting case law to borrow from.
Thank you, Alice. And maybe like in the interest of time, one of the last questions is looking at what's going on right now. And as you mentioned earlier, we see more and more these requests for reparation in the context of mass atrocities. So let's think about the register for damages in the context of the ongoing conflict in Ukraine. And you mentioned earlier, Yusra, that the court in the armed activities looked carefully into the practice and jurisprudence of some of the claims commissions, including your Eritrea-Ethiopia Claims Commission. Is there something interesting that we can gather from the practice of those claims commissions? And also, would they perhaps be a better alternative than courts or arbitral tribunals to deal with mass claims processes? So perhaps something like armed activities case would have been less challenging for a mass claims commission. I'm just wondering whether you have any thoughts on this, Alice, since you mentioned this, and sort of to make a parallel with your earlier.
Yeah, so, well, as you might all know, the register, the Ukrainian register for damages was established basically last year within the framework of the Council of Europe and after the recommendations of the General Assembly. And so far, it does not have any adjudicative functions. So the only, what has been established is that the register basically collects evidence, categorize this evidence and classify them in order to organize them in future potential claims. Now, if we look at past experiences and try to compare experiences of international claims commissions with the experiences of international courts, for instance, I think there are 2 points to be mentioned. One is that international claim commissions are established with the specific mandate to deal with reparation claim ensuring from situations of war in this case. And this means that these mechanisms structure themselves, organize their work, and adopt their rules of reference in a way that is specifically targeted to address the situation in questions. So both the UN Compensation Commission and the Ethiopia-Eritrea Claim Commission, before initiating proceeding for awarding reparation claims, equip themselves with clear rules that concern, for instance, the categories of claimants that could bring claims, the category of damages to be compensated, the standard of evidence to be adopted, causality as well. In some cases, they fixed a priori the amount of compensation that could be awarded for certain kind of damages and for certain categories of individuals. And in the case of the UNCC, for instance, the commissions relied extensively on the role of expert. And of course, this overall facilitated the compensation process, which in cases of mass atrocity, of course, assume a very big proportion. In contrast, if we look at the experience of the ICJ, of the European Courts of Human Rights, they may not be necessarily well suited to address compensation claim of this size and breadth. And at the end, they may not satisfy the needs of the victim of the conflict. And the second point is that if we set aside, for obvious reason and for a moment, the European Court of Human Rights, and we compare the ICC experience and the Eritrea Claim Commission's experience with the ICJ, we see that International Claim Commission seems to have prioritized the individuals in their claims. So, for instance, in the case of the UNCC, claims could be filed by states, by international organizations, but also by legal and natural persons, by the respective governments. But still, they were claims concerning individuals and corporations. And the UNCC at the end prioritized compensation claims given by individuals over those submitted to states. And there were, although modest, fixed amount of compensations that were paid to victims. And I think this is a key lesson to be borne in mind. And it is the reason probably why international claim commissions are more equipped and more well equipped to address this sort of atrocities. Of course, there are other considerations to be bear in mind. One is whether, for instance, a future international claim commissions for Ukraine shall take the form of a more administrative body, such as the UNCC, or a more judicial or quasi-judicial organ. And of course, you have to balance there the interest at stake. On the one hand, an administrative body may be more expeditious, more efficient, but at the expenses sometimes of legitimacy or due process, for example. And the final questions remain the problem of enforcing the awards. And I have to say that from this perspective, it is not necessarily the case that one form or the other will ensure a positive outcome, because in the case of the UNCC, that is probably the most successful case of compensation coming from international claim commissions, because it was established under the authority of the UN Security Council, and the Security Council provided that a percentage of the revenues of UN-controlled Iraq oil sales would go and would set aside to pay compensation. But in the case of the Eritrea Ethiopia claim commissions, the awards were made, but they were never paid. Instead, if we look at the arm activity case, we see that the first installment were actually paid by Uganda. So you see, it's not necessarily the case that different mechanism will ensure enforcement of the decision at the end.
This is a fascinating reflection, which also happens to respond, at least partly, to one of the questions from the audience, from Professor Mandel, who asks that what comes next with enforcement? International courts have no executive enforcement ability, and there are maybe issues of sovereign immunity that present a very hard bar to overcome. I wonder if anyone else has any reflection on that. This was the question to all of our speakers. And then there is also a question from Juan Pablo Perez Leon Acevedo, a question for anyone. Guarantees of non-repetition as a reparation form in the context of Inter-American Court, ICC, African Court, and or as a separate consequence of internationally wrongful acts. And the second one, reparations for violations of provisional measures as such at the ICJ, regardless of the merits outcome. And then maybe a question for Yusra, how to enhance the procedural standing of individuals in reparation proceedings at the ICJ. So several things, but maybe if anyone wants to still jump on the question of enforceability of judgments, more specifically as compared to with the decisions of mixed claims commissions and issues of immunities, and then the other questions that I have just raised, I will just give 1 minute to Christiane and Yusra to respond if you wish to say anything on these questions, on any of these questions. Maybe Yusra, go ahead first.
Yeah, sure. Thank you so much for your question. It's essentially the gist of my book in large part. So some very prominent scholars have actually argued that there should be an amendment of the ICJ statute, and Article 34 should, expand the locus standi to individuals. I personally, as I advocate in the book, don't think that's a good idea. I don't think that's feasible. I don't think that's practical. But I do think that there are a lot of creative avenues. We've increasingly seen over the years individuals kind of being included in delegations of states, and therefore having a certain, having the floor in oral proceedings. Of course, there's the witness mechanism, which the court seems quite uncomfortable with, but I think there is some potential for growth there. And in the advisory context, I also think, and this is more controversial, but the way that Article 66 has been interpreted quite loosely when it comes to arguable non-state actors, at least at the time, such as Palestine or Kosovo interventions, I do think that there's a little door that could be open for individuals to provide information where they are directly impacted. And Hugh Thirlway has also contemplated on that possibility. So I think there are ways to creatively give more space for individuals, and also just the state behind the scenes collaborating more with individuals for the evidence aspect, because that is critical when it comes to reparations being managed appropriately by the court.
Christiane?
Yeah, thank you, Vlad. I mean, the question of enforcement is a difficult one, right? It's the one we start with in any class of public international law, and that makes people skeptical of the existence of international law in the first place. In this specific context, I mean, if we use the example of the war in Ukraine, I mean, there is some movement regarding sovereign immunity on Russian assets, so I think that's something that might be an avenue in the future where those assets maybe could be used as a form of reparation. But again, the bar of sovereign immunity is indeed very high, and there's something to be said about sovereign equality and not eroding this principle, even from the perspective of other states. So I don't have a solution. I think the Security Council coming in, that's obviously an avenue, but in the Russian case, that will not happen. So no satisfying answer there. And it would be a miracle if I could give you one, because it's one of the eternal and most difficult questions of international law. I might have a better question on the answer on the question regarding guarantees of non-repetition as a form of reparation. I mean, traditionally, the ILC separated cessation and non-repetition from reparation, right? And that's precisely because states other than the injured state can actually claim these two legal consequences of the Internationally Wrongful Act. So in principle, that was one of the effects that I mentioned of making the regime more objective and letting go of damage as a requirement for responsibility. Some people have criticized that, like Brigitte Stern. She has written an article about fracturing the unity of the regime of reparation. In my view, one could argue, one could subsume guarantees of non-repetition and cessation into reparation, but that's not what we see in the ASIWA, So I think this is also something that it's an interesting question to be discussed. I don't think that the ICJ is taking a clear position on that, but it's actually following what the ILC does. So thanks.
Thank you, Christiane. To be provocative for our listeners, imagine that tomorrow you're a sitting judge or arbitrator, and we have heard a lot of food for thought in terms of areas where things are not quite there as we would have ideally liked them to be. In 1 minute each, which would be the area you would single-handedly dedicate your days and nights to work out for a better reasoning, which could be then extrapolated on a more general level? Maybe I will start with Alice.
Well, I might be very obvious, but I will say causation and causality. I think, as I said, it's one of the most thorny questions that courts have been addressed, and it is key, I think, even because as Christiane at the very beginning, Yusra at the very beginning said, well, it is the principle of full reparation. It is stated there in Article 31 that there must be a causal link. And both, practice in this sense is still very obscure. So I would say that the court at some point needs absolutely to address this problem.
Causation, well taken. Yusra?
So many things. I think I would probably like to see some development in the area of clearly stating that reparation is owed to the injured individuals in the context of diplomatic protection. in mass human rights claims specifying that states should give the reparations owed to the individuals, maybe even proposing maps or avenues to do that. And more broadly, perhaps when talking about crippling compensation earlier, taking into account the financial burden imposed on the responsible state and clearly stating that this is a factor.
Great. Christiane?
Okay, I mean, I'm with Alice on causation. I think that really needs to be clarified, because it's much more important than just for the calculation of compensation. It connects the wrongful conduct with the damage. It is important for determining the remedy that we might decide on, and it is ultimately also decisive in calculating the extent of compensation owed. Since I was in the past a member of the project on shared responsibility in international law, I'm also very much with Alice on the problem of overdetermination. So multiple causes for the same damage that we've seen in armed activities and in certain activities, and the court has actually acknowledged this issue. But it's just not dealt with it very well. I mean, we might have seen cases of awards of compensation earlier if causation had been clarified or was clearer to the court. For example, in Gabčíkovo Nagimaros, both parties actually claimed substantial compensation from each other. And then the court suggested some kind of zero-sum agreement for damages that would be appropriate because Slovakia and Hungary were both entitled to compensation. So, I mean, and that compensation canceled each other out, which seems a little bit odd. And maybe in this context of highlighting multiple causes for the same damage, I also want to underline that actors other than states are important in causing damage. Non-state actors, armed groups, but also corporations, and that's particularly important regarding environmental protection and climate change. And yeah, especially in this field, as I think Alice mentioned that, as we see have several big advisory opinions still coming forward on climate change. Causation should play an important role, and we can only hope that those opinions are going to further clarify how to apply causation. Thanks.
Absolutely. My role as moderator, I couldn't agree more. And I'm happy to see that there have been quite a bit of scholarship recently on both issues of shared responsibility, to which Christiane has contributed quite directly, including with her and other colleagues' article in the European Journal of International Law, but also on causation, which Alice has written on with a particular focus on the distinction which has to be done between factual and legal causation, but also digging deeper in the history of international state responsibility on these issues. I myself have produced some insignificant scholarship in comparison on this topic. So scholars are increasingly interested in these things, and perhaps somehow indirectly, all of our listeners may come a little bit with some ideas as to what to write, or maybe what bothers them, what doesn't allow them sleeping at night. And there is a great opportunity, and I will use here my chapeau of the American Society of International Law to contribute your writings and your thoughts in the context of the ongoing call for papers by the American Journal of International Law Unbound, which is seeking contributions specifically on reparations in international law. So with that in mind, I would love to thank you for your contributions. This was fascinating, very enriching discussion, and I hope that our attendees have also enjoyed it. And thank you very much, and until next time.